Hello, good morning, good afternoon. Thanks for joining us today. We're having this conversation today for the occasion of the World IP Day, which was yesterday. World IP Day is celebrated every year on 26th of April. And this year, WIPE also dedicated this day where we remember the role of IP in encouraging innovation and creativity. And this World IP Day puts innovation and the IP rights that support it at the heart of the efforts to create a green future, said WIPO. Why? Because the choices we make today will shape our tomorrow. The earth is our home, we need to care for it. This crisis we face now is also very much related with this message because we need to care for our home and our future, and any decisions we make today, especially on IP for the occasion of this day, will shape our tomorrow, will shape our future, especially the R&D and investment environments for now and for future crises. So today, for the occasion of this day, we contribute to this message by talking more about IP with my colleagues and their friends, Selin, Sinem, Erciyas, and Zeynep, Seda, Alhas. Selin, Sinem, Erciyas is a partner in our practice group, patent practice group. We work together with Sinem, and we will discuss with her the latest developments on compulsory licensing, patent sharing globally. Whereas with Zeynep, who's a partner in our trademark design, civil and criminal law practice groups, we will discuss about developments with a focus on Turkey specifically, and how the enforcement activity and court actions proceed under these circumstances. So good afternoon, both of you. We were all together conducting this conversation this morning. So after a plate of pasta for lunch, we're back. Thanks to the stocks, we have a lot of pasta in home, so that's what I had. I hope you are well.
Thank you, Özge. Yeah. It's good to see you again.
Yes, good to see you again. I see you are at the office still.
Yeah, I am. I actually, honestly, I missed the office. And in the morning, I repeated it when I'm driving this morning to office. I felt that these little things can make me, and I think everyone, very happy. So we needed to understand the importance of these little things to, drive by car to office and listen radio during the way, etc. Yes. So I'm really happy, and I missed my office. And I have two little monsters back at home, so it won't be possible to, this firmly to talk to you. So that's also a reason for me to be in the office.
Good, very well. So, especially when, if we start talking about the compulsory licensing and patent-related developments in the world, we see that some of the, well, both individually and as states, it would be difficult to say that, we are prepared. This is such a difficult and different crisis. But at the same time, when our eyes are on states, big institutions, NGOs, we want to hear more and more predictable messages. But we see that also in this area, investments, R&D, and encouraging those, we start to see states also panicking and declaring also some measures, and these measures in some jurisdictions create the question whether the investment motivation would be interrupted with these provisions and measures. So the unprecedented nature of this crisis, both economy and medical crisis, let's say, such measures may become more attractive, even in jurisdictions where, you know, compulsory license is not discussed often. So Sinem, what can you tell us about these latest developments in different jurisdictions, and how do you think those measures create the balance between innovation and access to hopefully a vaccine or a medicine here?
Yeah, thanks, Özge, once again. This is a very extraordinary time, as we all know, because this is such a time that we drastically and urgently need an invention, because the existing APIs in the market seems not to be the treatment for this COVID-19, at least not for the, how to say, certain treatment. They may work at a level, but they are not the ultimate solution, ultimate treatments. So we are in need for an invention, but invention seems to be the solution for this crisis to combat with this, but it also seems like a hurdle before the access to this solution. Because most of inventions, of course, if an invention could be done within this period, it will be patented. This is the idea. So the countries, when we look at the countries and governments, they all, mostly all, of course, not all of them, but most of them thought that, well, there will be an invention soon. There needs to be, so I should also be prepared as a government, as a country, to make use of this invention. So I need compulsory licensing. This is always, or the most times, let me say, linked together. If there is invention and if I want to make use of it, then there needs to be a compulsory licensing from the point of view of a country or a government, of course. We will talk about it in detail maybe if we have time, but I do not think so that is the right way of looking to the matter actually, because especially for this extraordinary time, I think compulsory licensing and provisions that are strengthened, empowered to, you know, grant compulsory licenses have some kind of chilling effect on the possible invention incentives and invention motivation. I will planning to maybe talk a little bit later in detail, but we all know that the big innovator companies, they have shareholders and they have, how to say, an aim to profit. This is how and why they exist. So the IP is one of the very important tools for these innovative companies. If you say just from the beginning that you are getting ready for a compulsory license issue, how you at the same time can give that incentive and motivation to that company to invest in such a difficult project, let me say. Mm-hmm. We experienced,
the interesting part also is that usually these discussions are made by certain countries, and we usually refer to the certain part of the world. But this time, even countries which rely on IP, rely on inventions, also started to take measures, right? For example, Israel and yes. Maybe you can give more information about
yes, that. Sure. I mean, you're right. Very unexpected countries took unexpected measures. For example, as you just mentioned, Israel is the first country in this period that granted a compulsory license over a COVID-19 treatment, let me say. We all know that it granted a compulsory license over a Kaletra of AbbVie. And this compulsory license terms that the product should be imported from India. So Israel does not say that, because as far as I know, it has the capacity, we all know, but it does not say that I am ordering a compulsory license or granted a compulsory license to have Kaletra manufactured in Israel, but instead it says that it will be imported from India. So many things that we know that Caledra is patented in Israel, but not in India. So even in that situation, I think Israel is trying to take a position, let me say, an interim position. It does not want to overcome all patent rights. So instead, it just orders this compulsory license to have Caledra imported from India, where there is no patent protection for Caledra. And it is, I think, still saying us something that, yes, the very unexpected countries may reacting this situation with compulsory licensing, but some of them at least trying to find an interim way. Some criticize it very much, but some says that, well, it just tries to, you know, to find a solution between two situations. But very similarly, there's Germany, there's France, there is Canada. They all either strengthen or empowered their compulsory licensing provisions. All of them had already compulsory licensing provisions, but they brought new amendments, let me say, to simplify the procedure. For example, Germany says that normally the federal government is entitled to grant a compulsory license, but now the Federal Ministry of Health is also entitled to grant the compulsory license. And for France, we all know that the president is given really wide authority to grant compulsory license and also to size the documents, the products, the medicines. And in Canada, there is this COVID-19 Act that is granted on 22nd of March. And it also gives the Federal Ministry of Health to give the authority to the patent commissar to grant the compulsory license. So they all, these three especially, found a solution, found an interim way to ease the procedure for the compulsory license. Whereas we also see the United Kingdom, which takes an, let me say, softer approach, a patent pro approach maybe, because we all know that United Kingdom is a patent pro country. And what it did not strengthen or empower it is existing provisions. It does have compulsory licensing provisions. Instead, it said that, well, there is this crown use defense in our law, so it can be used in case, you know, if a person or a company is ordered by the, you know, government to make a manufacture, to manufacture a certain good or medicine, and as a result of this manufacturing or production, if it faces with patent infringement accusations, then it can use this crown use defense, which means that the company or the person was empowered by the state, by the crown, to make this manufacturing. So it can prevent or defend itself with this umbrella provision, let me say. Another thing, another approach UK took is, it said that if any company is faced with patent infringement actions because of, you know, manufacturing again ventilators or PPEs or medicines that were ordered by the government, these will be protected against the compensation or legal costs of such patent infringement actions, which again says us that UK does not push the patentee or does not put the patentee in a difficult situation as it must find a way to protect itself. Instead, it foresees that there may be some infringing acts. It's an extraordinary term, but then if in case of such acts, it says that the possible third parties, the so-called infringers, will be protected by the government. I think it's, of course, not suitable for every country, I admit, but it's a kind of patent pro approach, and it's kind of different from the rest of the world if we think that most of the countries are just going with harsh over compulsory licensing issues. And there is the United States of America, of course. There was this famous Bayh-Dole Act of the United States, so it did not need another or strengthened or empowered provision to apply the compulsory license over patents, and Bayh-Dole Act already says that if there is an invention done via federal funding, then under certain circumstances there can be a compulsory licensing. I think it's not a coincidence that the coronavirus package that was announced a few weeks before by the President Trump includes a $3.1 billion US funding for the research and development of the pandemic. So this is a huge amount for most of the countries, and I think they are already considering for compulsory licensing as well, because this is the federal funding of the the $3.1 billion is a huge amount, as I said, and if it is necessary, they can just use the provision coming from the Bayh-Dole Act.
Not so big, as we do not know the value of the patents, and it's a tricky issue, of course, to grant the correct amount, let's say. But of course, compared to many countries.
Sure, and many authorities in the US, they already declared that this amount is quite insufficient. I should say it as well. But again, my thinking is putting that amount of money as a federal funding in this package needs some kind of security behind it. And the Bayh-Dole Act is giving that security to the United States. It says that if there is federal funding, then there can be a compulsory licensing. And US has also another mechanism, so-called Defense Manufacturing Act, if I'm not mistaken, Defense Production Act, and this was empowered and enforced against General Motors by the government. General Motors are ordered to manufacture ventilators and personal protection equipments in the high amount, in a cheap price, and rather fast, let me say. And this was done and ordered to General Motors under this Defense Production Act of the United States. So there are different mechanisms working in every country, but except for UK, as far as I can see, and except for Turkey, I have to say it as well, because we did not also strengthen or empowered any of our compulsory licensing provisions. Of course, we already have the necessarily good ground. This may be one reason if we need somehow this kind of move, let me say, that the legal ground is already ready. This may be a reason, but looking at Germany has also the very similar provisions, but still it said that, okay, I'm giving the authority to the Federal Ministry of Health instead of the federal government only. We did not take such a measure yet.
But actually, there was a slight change in the IP law from 2017, but the compulsory licensing due to public interest, that provision did not see any change. Rather, it was on the not voluntary, but based on a request to the patent holders in case of this insufficient use criteria. There were some changes, but from those days, we both know that because Selin and I joined the parliament discussions for compulsory licensing on behalf of the innovators, and there was a great discussion. It was a hot topic, even though we haven't seen any examples in the pharmaceutical sector. Compulsory licensing was one of the major issues.
You're correct, Özge. Actually, the main difference, the main amendment in our law coming from 2017 in our new law, industrial property law, was the issue related with the compulsory license due to non-use of the patent. Because previously that provision was saying that if a patent is not used within 3 years as of date of grant, etc. So the main issue was the patent to be non-used. But this time the new provision under the same heading says if the patent is not used or if the use does not satisfy national market need. So there's another issue here. There's a use of the patent holder, but somehow the thinking is that the use is not satisfying the national market's need, which means that the production amount is not satisfying the need. So there can be a compulsory license again. There had been quite debates over this provision because it was quite vague What does it mean? What do you mean to satisfy national markets need? Any product, any product should satisfy the national markets need just because it is protected over patent. Because actually the aim was the medicines, we all know, but the provision does not put an explicit limitation that it is talking about the medicines or any other product that meant importance, that had importance for public health or public defense issues. It just says a product.
Yeah, a lot of jurisdictions are familiar with also insufficient use criteria, but the problem was the vague language and the discretion on determining whether it is an insufficient use or a sufficient use, etc.
Yeah.
But even at that time, we were questioning if there was a compulsory licensing, whether this condition that we just discussed would be applied, or whether and when the government would directly go to the public interest cause, because
Yes.
public interest cause is pretty vague as well. As you said, no measures has been taken. Probably this is seen as sufficient, or there might not be any need in Turkey due to the other measures taken by the government. On the other hand, although there is no pharmaceutical compulsory licensing in Turkey, just a couple of years ago, based on the information in the media, there was also a patent-related discussion with respect to SMA patients and the government's role in supplying these products. So it was not so clear whether there was no compulsory licensing, we know, but whether there were serious attempts or which provision the government would use. So that was the time that felt very close to us, I remember. But we actually don't know how ready we are. It seems like there's no preparation or there's no need for it. You also look at some of the APIs, active ingredients related to this disease and pandemic, and whether they are patented or not. I know that. But I don't know still if everything is ready for that also in terms of regulatory filings, how such a product would be approved, etc. There's no clear provision in the licensing regulation yet. There was a draft, but we don't know what happened to that.
You're right. Well, the first thing, so far, like it happened in the United States or in Brazil, the compulsory licensing provisions are used as a tool to negotiate over the price of a medicine. And it's unfortunately worked out. So far in Turkey, this is the situation we experience. Some government officers mentioned about compulsory license, or in some cases even threatened the pharmaceutical company over compulsory licensing issues, but it was just, at the end, we understood that it was just because of the price negotiation issues. Maybe if there was no deal, there could be a compulsory licensing, but as I said, so far it was just a tool for the negotiation.
Yeah, we've seen in some cases, not specific to the one that I mentioned, but yeah.
And when we look at the compulsory license due to public interest provision, which is Article 132 in our law, it is, as I said, a very wide provision. It's ready to be implied in any case of public interest. So if needed, there is no need for any other thing. As I said, the president is authorized to decide on the compulsory license due to public interest, and this mechanism would work quite straightforward and fast. Will we need it? For the time being, I don't think so, because the Ministry of Health published a guidance how to treat the adult COVID-19 patients. And in that guidance, some APIs are explicitly mentioned, and even the dosage, how to treat the patient, how many milligrams should be patient given, etc. And looking at these APIs, yes, These have some secondary patents granted in Turkey in the name of various companies, but there is no API, compound patent. And the secondary patents could be enforced, but the companies may also refrain from enforcing them for two reasons. First, they may think that they cannot prove the infringement, or the patent can be bypassed if it is not a very strong one. And secondly, of course, there is this publicity, the publicity power, the power of the publicity, because any company who takes extraordinary measures in these terms, like not opening the, let me say, technical information, not letting the patents to be used by third parties, etc., are facing with serious publicity, negative publicity. Again, these are pharmaceutical companies that have shareholders and have the ultimate goal to make profit, so they cannot risk such a bad publicity, which obviously will not be forgotten in a recent time. So I can also mention some kind of approach coming from these companies as well, if you wish. For example, the first how to say, serious action has been directed to AbbVie, the Kaletra. As I said, Israel has been the first and so far only country who granted a compulsory license over Kaletra of AbbVie. This product, Kaletra, is already a product listed in the medicines patent pool of Unitates, which means that it is licensed, it has been given license for the HIV treatment. What happened differently when the Israel comes up with the compulsory license decision over Kaletra, AbbVie make a public declaration and said that, well, I let everyone to use Kaletra for any indication. So it has become available for everyone for any indication, not only HIV. There is no other explanation why AbbVie did it. It did not want to go to details, obviously. But of course, publicity is an important issue here. And of course, it made a calculation of pros and cons. Of course, reputation. And it just gave up, basically. And there is, for example, another example of Gilead from the United States. I don't think so that, I mean, you may interpret this move as a negative way, but I do not take it as a negative way, because I think Gilead was in that terms trying to do something good. What happened is Gilead applied to FDA for the early cases of COVID-19 in the United States and said that these should be classified under a rare disease. That's why it's remdesivir that is used in the treatment of the COVID-19 cases should be listed as an orphan drug. Of course, I'm not an expert of the US regulatory law, but it gives us I know that it would give us extra 7 years market exclusivity to Gilead, and somehow this created a publicity kind of criticism over Gilead too, and it's eventually said that, okay, I voluntarily give up. I withdraw the market exclusivity. So on one hand, there is this compulsory licensing pressure. On the other hand, there is the publicity, reputation, and none of these companies would like to be misunderstood. But in my opinion, they need their IP. We need to understand that. We should not take the issue like that simple, okay? I mean, what I'm trying to say that, well, they have the patent right and everyone needs to have access to medicine, so let's put a compulsory license over it and deal with it. It's not that simple, because what we need is an invention. And to have this invention, we need to motivate these companies, right? To make the invention.
Yes, definitely. But on the other hand, of course, we always talk about compulsory licensing theoretically or as a threat for the patent holders, or in terms of a balanced interpretation of the same for access to medicine. So one can can ask if this time is not the best time for compulsory licensing, when is the best time for compulsory licensing? So what do you see this term as different, or what is the basis of your point?
Well, the short answer is I do not think so that it is the best time to grant a compulsory license, because the situation is not like this. For example, there is the pandemic, and we know that the, let me say, X API is a cure for it, and we need to manufacture that API as fast as possible, as many as possible, and as cheap as possible. Okay, and in that kind of situation, I can understand that the API is there, and manufacturing has to be huge, and there may be a justification for compulsory license. I can agree, but in our situation, we do not know the cure, the treatment. We need an invention to know it, to find it, and to have these companies to make this invention. Or I know many of these companies are working with governments, so it's a cooperation. But anyway, the private sector is highly involved in it. And to motivate them, to give the incentive, we should, of course, not put the compulsory licensing in the first role, because it, in my opinion, certainly demotivates these companies who has shareholders to respond, and who has to survive for the future pandemics as well.
Yeah, and the compulsory licensing cannot be the only tool, because the issue, when you said, we need an invention, I thought about whether all vaccines are inventions, or at least patent protection is valid or not. No, so patent is not the only answer also, right?
Right, because whoever invents this treatment may not have it patented. And then what happens? For example, let's imagine X country found the treatment, but no one applied a patent application for it. It can be the case. There are many companies, which are our clients as well, that prefer not to file patent applications, just to keep the trade secret for itself forever, because they trust it so much that it cannot be found. It cannot be via reverse engineering, etc., reinvented by anyone else. So there is the very important thing, like the know-how. The patent, in many cases, even the patent is not that clear. If the patent, if there is the patent, it just does not mean that, oh, okay, I just look at the patent document, the specification, whatever it is, and I will go with the product to produce the same product. Especially most of the vaccines are not under patent protection, because know-how is the main issue there. So there needs to be some creative thinking. We need to think out of the box. It's not that easy. To just bring compulsory licensing.
There is no box. At this time, there is not even a box, but still.
Yes, you're right. As I said, we need to think creative. It's not that simple. Just put the compulsory license down and then everything will be fine. Not like this, unfortunately.
Okay, thank you, Sinem. As we are almost little after half of the time, I will turn to Zeynep. Zeynep, you've been silent for half an hour. Say something.
I'm dying here.
How are you? You also seem very well.
Yeah, I am. Thank you very much. I just want to say briefly hello to everyone. Thank you for attending our webinar today. I hope everyone, all friends from all around the world, you are safe and your loved ones are healthy as well. And happy belated World IP Day.
Yes. Zeynep, your practice is at the heart of enforcement, both criminal, civil, and I know you are very close witness to what's going on in the courts. So let's inform our friends and colleagues what is the status at courts today.
Yeah, so let's go local. Basically, the situation with the courthouses and the courts was complicated for a while. And neither us nor the court personnel, the judges and the prosecutors, we weren't aware, we didn't know how the effects of COVID-19 should and will be handled. By the beginning of April, we can say that it became clearer to us as well. In short, the courthouses, and I'm going through the judicial system in general, not the administrative courts, but from an IP point of view, the courts who are dealing with IP mostly, the courts are now working as if we are on a judicial break. I can say that it's a flexible working arrangement, which is a term we usually come across in private companies mostly. But it's basically the same. The courthouses have the minimum numbers of judges, prosecutors, and personnel as needed, who are considered on duty. They're working on a daily basis, and the rest of them are working from home, working away. And on-duty personnel changes regularly. At the very beginning of the COVID-19 pandemic in Turkey, I think it was March 11 when we officially confirmed that we have cases in Turkey as well. The presidential instruction dated March 13 came, and they said that several judges, prosecutors, and the courthouse personnel will be put on administrative leave for 12 days. Those people are the ones who have chronic illnesses, or the ones that are above the age of 60, who are unable-bodied or who are breastfeeding, they're on leave for breastfeeding. These were the first group of people that were let go by the presidential instruction. So 12 days later, another instruction came and said that these people will remain on administrative leave for an indefinite time until a second order comes from the president. And the Council of Judges and Prosecutors stepped in, and they put another group of people to the ones that are put on administrative leave. These people are the judges and prosecutors whose spouses are working in the medical industry. So they are dealing with the they can be either like private practices, they can be governmental hospitals, they can be either one of them. So if a judge or a prosecutor's spouse is in the medical industry, or even if they are like nurses, they're doctors, they will be on administrative leave as well. With another communique of the Council of Judges and Prosecutors, they set forth the general rules of the working arrangements for the courthouses and the district courts as well, by the way. So they said that only the necessary numbers of judges and prosecutors will be at the courthouses on a regular working day. And this will be treated as an on-duty system. And the presidency of the Justice Commissions and the Chief Prosecutor's Office at the courthouses will decide which personnel, which judges, which prosecutors will be on duty on a given day. And they will change it as necessary. And they also said that, the council also said that the civil judges will be taking care of the criminal courts matters as well. That is because the most urgent matter in such a pandemic seems to be the criminal court files with accused in the jail who are being treated while they're at the jail. So this seems as a priority to the criminal courts as well. And whenever that is necessary, the civil court judges will step in and take care of those as well.
So as an civil IP judge on duty can hear criminal cases as well?
Yes, and these will be treated as priority matters too. So this civil court will have their priorities too. They have urgent matters such as discovery of evidence proceedings, such as preliminary injunctions. But above all, this will be the imprisoned accused files, so they will be the priorities for them as well.
What about the practice? I know we've discussed also in this morning and previously our experiences, because each court may have different approaches. And yeah. Sinem, maybe you can have a recent example as well. Zeynep?
Yeah.
Maybe we start with Zeynep. Sorry, Zeynep.
It's okay.
Yeah. So yeah, the practice So basically, the preliminary injunctions, discovery of evidence proceedings before the civil courts, they are also considered as an urgent matter. So the civil courts or the criminal judge who has the duty that day should be taking care of these urgent matters on behalf of the civil court's original judge as well. But my personal experience so far within the last 2 months was not very positive, unfortunately. So we experienced that the judges do not give the priority to those matters that much. We were expecting them to be more free in a way, because they don't do hearings, that they don't go out with the experts for examinations. So we thought that it can be easier for them to prepare the rulings for the preliminary injunction as well. My experience was the other way around, unfortunately. My most recent case is before a specialized civil IP court, and we are expecting a decision against an online infringement matter, which is very basic. We had gathered all the evidence as well, but we are still waiting for the initial preparatory minutes to be drafted. So maybe Sinem has different experience with that, but mine was really not encouraging.
Yes, mine is encouraging because I filed, my team together, of course, we filed 3 different discovery of evidence and precautionary injunction demands during this pandemic phase time, let me say. And 2 of them are under expert examination because of the technical
They were sent to the expert examination, right?
Yeah.
Without waiting.
No, without delay. The opening reports were drafted, and due to the technical nature of the matters in both cases, the different judges, by the way, the 2 different judges decided to have expert examination on these demands and issues to discover the evidence and to evaluate the patent infringement, of course. In the 3rd one, we already received the decision. So in terms of procedure, there was no delay, and we could move forward easily. As we discussed in this morning, maybe this is the reason we applied just for a discovery of evidence and a precautionary injunction demand. So it's not an action on merits. It's just for the discovery and injunction demand. And as far as I know, Zeynep's experience is depending on the action on merits, but in which the precautionary injunction was also requested. Maybe these are affected from the, the usual way of interpretation, the action on merits, despite they include a precautionary injunction demand in them. It may be foreseen. I don't know. I don't want to comment. Maybe, I don't know. I mean, but for me, it was quite straightforward.
Mm-hmm.
And the patent matters are more interesting to the judges, I guess.
Well, depends. Some
compared to soft
I don't think so.
Sometimes
they may. Anyways, yes.
Yeah.
Continue.
But yeah, apart from that,
dangerous to comment.
Apart from that just nerve-wracking delay in this preliminary injunction matter, the things are pretty usual. We can say that we have this online judicial system. It's called National Judiciary Informatics System. I can translate it to English like that. So basically, we do everything through online means of the judicial system. We can file petitions. We can follow up the other parties' filings. We get online notifications as well. And even this is a new development that came with the COVID-19 term. The files before the local prosecutors' offices were not available to us as lawyers before COVID-19 term, because these are considered confidential, the prosecution phases, even to us as lawyers. Whenever we go to the courthouse, we can see the actual file, but we didn't have access to this informatics system, the online system. So now it's open to us as well, which makes our job easier for the counterfeiting matters as well, but I won't go there just yet. And I will have one more comment to make before
Turkish Patent Institute, maybe.
Yeah, and the deadlines in general. So we know that the legal deadlines in the Turkish judicial system, as well as the administrative proceedings before the Turkish Patent Institute, has been suspended. The most common day is March 13. We have some exceptions to that. Some matters are suspended by March 22, but March 13 is the most common one. So basically what happens is we have a bit complicated way of calculating the new deadlines. I won't go in there, but basically all legal deadlines that were pending by March 13 has been suspended until April 30. So they will reinstitute by May 1. So we had the opportunity to get back to our clients who didn't take a necessary action, maybe the payment of a renewal certificate for a trademark by March 13, and we could go back to them by March 20 say that you can still make the payment. All the legal deadlines have been suspended. That applies to criminal and civil procedural codes, so all other laws that contain a legal deadline. So the terms determined by the judges as well. Sometimes our judges give us definite terms to take an action, and these are suspended as well. And that applies to mediation and conciliation facilities too. And these all apply to the deadlines before the Turkish Patent Institute, to the payments, to the oppositions and appeals, to the court actions that we can take against office decisions. And the most common exceptions to those are basically the statute of limitation on crimes, administrative sanctions, and the preliminary injunctions, the deadlines related to the preliminary injunctions determined by the civil proceedings law, and the preventive measures determined by the criminal proceedings law. So these are exemptions, but we can say that almost all legal deadlines have been extended due to COVID-19 as well.
Thank you, Zeynep. I still, hear some colleagues, even though terms are extended, they see this time very productive, and irrespective of the extended deadlines, they work and make filings.
Yeah, by the original deadlines.
Yeah, yeah. But it's of course very relieving that there is no loss of rights.
No.
What about your enforcement activities in the field as well as customs? How about the demand from the clients? Is this their priority, and how things are conducted in practice?
Yeah. So yeah, the actions at the field, I can say, mostly those are referred as the anti-counterfeiting side of things. These are demanded by the clients, and they have all the right to do so, because IP rights are not something that you can let go, even in a pandemic era. And it is indeed possible to file complaints and act against counterfeits. And whenever we get a preliminary injunction decision, we can have it enforced as well. But we have to say that the courts are working in a more flexible way nowadays. So as the prosecutors too, and when it comes to law enforcement, the police, their priorities has shifted too during this time. For urgent matters, we can still take action, and we don't advise our clients to wait until the end of this term, which we are not really sure when will end. It's not easy to conduct investigations either, but we still do conduct those for online infringements. And wherever a local businessman is doing business, and by business, I mean either manufacturing counterfeits or selling them or infringing someone's IP rights, we do our best to take action against those. I can say that during this time, we have more demands from our clients who are active in the pharmaceuticals, the cleansing products, the masks, whichever products are more appealing to the local people for the time being. It can even be like food products as well. During a time like this, they need those more than any time any other time. And the counterfeiters and the infringers, they are aware of that as well.
Open to abuse, especially in this time.
That's a huge abuse. That's the worst thing that someone can do. The pharmaceuticals, the cleansing products, they are really, they hurt the user directly. And the police and the prosecutors are aware of this abuse as well. And in fact, the Directorate of the Police in Ankara has instructed all 81 local police teams, and they have took very strong actions against counterfeit suppliers. And within the last 2 months, I guess, they conducted raids all around Turkey, but especially in Istanbul, Ankara, Gaziantep, Adana, and they seized tons and tons of like counterfeit products, these protective products, and pharmaceuticals as well, the cleansing products too. And we have many clients from this sector who are really interested in supporting the police, because the police take those actions based on health regulations, public health regulations, these provisions. But we back them up with the IP provisions from our IP code, which makes the offense of the other party much more grave than original. So they are treated accordingly. So yeah, the counterfeiting measures that we can take them still do, but we have to say that it takes a bit more time, and it can be a bit challenging because we don't want to put anyone's health in danger either. So we have to act carefully.
Thank you, Zeynep. Did you have anything else to cover? Anything to add? Otherwise, there's one question.
Maybe I can, if it's not related to that, maybe I can make one comment about the customs protection.
Yes.
So I just want to say that these continue as normal. The people at the customs, they are not exempt from the this easier way of working either, but we know that the importation and exportation is not as busy as it was before, and which allows the customs to go through much more imported and exported products as well. So we can still file customs IP recorders. It is online and it's all in good order. So we receive suspension decisions from all around the world. And what we could start doing during this COVID-19 era is, we were in touch with customs for them to send us the photos of the products they seize for quite some time now. And the EU was involved in it as well, because we had to go to the customs each and every time a suspension was made. So now they started to send us the photos themselves, which makes our job much more easier, and for the client as well. So there's a slight silver lining there. I know it's not big. So we started getting extensions in terms of the deadlines from the customs that we never did, mostly in Istanbul customs. So the protection of the IP rights at the customs are good and proceeding as normal.
Mm-hmm. Good. I think these bring also more cost and time effectiveness for the companies.
It is.
So it's very good. The question actually was in relation to a trademark opposition. Hello, we had a deadline for filing a trademark opposition on March 13th, but missed it right on March 13th. Would we still be able to file an opposition?
Yes, you can, and I will let you know the deadline as soon as possible.
You're opening up the chart.
I know the Turkish Patent Office has issued a chart, because it's not really very easy. But maybe I will need a bit time though. I will find it right now.
Take your time, Zeynep.
Thank you so much.
Yeah, we have 5 minutes. And
no, Özge, I just recognized that you did not ask me about my brilliant solution for this crisis. You just make me criticize the system.
Yes.
And
I will give you the last word.
Thanks a lot.
Because I talked about my preferred
solution. What about mine?
Where the states could own the patent rights, etc. Yes. But I will come back to that. Sorry about that.
No problem. We already give a spoiler. So.
Okay, it's June 30.
30 of June.
Yeah.
30 of June.
It was March 13, right?
Yes,
right.
March 13.
March 13, sorry, it's 15 of May. I made a mistake again, I hate this. So if your original deadline was March 13, it's going to be May 15th.
So yeah, there's plenty of time.
Plenty of time to do that.
Good, thank you. Thanks, Zeynep. So as promised, I will come back to Selin's point of
by force
solution. And with that, we can wrap up.
Yeah, it's not, of course, my invention, but there's a very effective system already running, which is the system of the Untitled, the international organization. I just mentioned about it actually, about the medicines patent pool that is created for the HIV treatment in the needed countries. And NPP is just decided to expand its activities for COVID-19 treatment as well, temporarily, of course. But it seems that it's, for me at least, an interim solution, because it just does not put a compulsory license over the inventor. It takes licenses, voluntary licenses, and it has, it makes the generic companies manufacture the necessary medicine product over these licenses, and so both goals are met. I mean, the patentee is happy because it did not face with this compulsory license issue, and the product could be reached by anyone needed. So this is not my, of course, inventive solution, but this is the one that I found, especially for such a time, kind of a useful solution.
Thank you. So this is what we want to cover, and I checked the questions and will respond with the questions. Thanks for joining me, both this morning, this afternoon, and everybody joining us in this conversation. It felt good to us how we celebrate the World IP Day today. We enjoyed it. We hope you enjoyed it as well. I would like to also talk about our hub, COVID-19 hub in our website, not only on IP in every field of IP, also in other law areas. We provide updates very frequently, so if you have any questions, please look at our COVID-19 hub. And last word from Zeynep and Selin, Sinem.
Well, I thank everyone, and it was very nice to be with all of you. Thank you for joining us, not leaving us alone. it means a lot. And yeah, hopefully next year we can have a big party to celebrate World IP Day. That's my wish. Thank you.
And again, thank you all for joining us today. It was a real pleasure getting to celebrate World IP Day with all of you, though it was without human contact. And I truly hope that we can be like healthy and free to see each other in person next year and earlier maybe.
Yeah,
hopefully. Okay. Bye-bye. Thank you. Thank you for being with us.
Bye-bye.
Bye-bye.